Okay, let me begin by saying this is Oakley Township Homeowners Association Incorporated versus Nathaniel Perdue, and this is 2021cv352013. Today is March 14th, 2022, and we are appearing today entirely via the Zoom teleconference platform. I am in my chambers or office here at the courthouse. Our courtroom is currently being used to try a criminal jury trial, and we are otherwise out of courtrooms. Accordingly, I have put this hearing on the court's YouTube live stream channel. Now, let me explain exactly what that is, because that is a publicly accessible means by which we can fulfill our obligation to make certain that the public continues to have access to its business, which it's entitled to have access to. If we were in the courtroom, anyone interested could walk into the public courtroom. Since we are not in there, we've made it otherwise available through the YouTube live stream channel. However, prior to concluding our connection today, I will turn off that YouTube live stream, which should have the effect of making sure that it's not permanently on YouTube. So that's that, and I'll just ask everybody to introduce themselves. Mr. Joseph, you want to go first?
Yes, Your Honor. Richard Joseph, appearing for Oakley Township, the plaintiff in the case, and we have a pending motion for summary judgment.
Okay, and Ms. Claire?
Yes, Diane Claire for the defendant, Nathaniel Perdue, and we entered and filed a amended answer as well as an answer to the plaintiff's motion for summary judgment.
When did you do that, Ms. Claire?
Which one, the amended answer or
the summary judgment response?
It was filed February 10th, 2022.
Okay.
I think you issued an order saying I had extra time to file.
Okay, yeah. Okay. All right. It is on for the plaintiff's motion for summary judgment this morning. And Mr. Joseph, I'm going to ask you if you'd like to go forward.
Yes, Your Honor. May it please the court, Richard Joseph for the plaintiff. On July 19, 2021, plaintiff filed its complaint, cause of action being for unpaid homeowners association assessments for property owned by Mr. Perdue in the Oakley Township development at 7381 Melhana, M-E-L-H-A-N-A. The complaint sought and claimed $2,200 principal, $440 in prejudgment interest, plus attorney's fees, costs, and expenses. The defendant was served and filed an answer, and plaintiff filed its motion for summary judgment back in October, supported by the affidavit of the property manager, Brian Ball, and my affidavit as to attorney's fees and litigation expenses. The defendant requested and was given an extension of time to respond to the motion for summary judgment, and as counsel observed, that was filed on February the 10th. It is clear from the pleadings and records in the case that, first of all, the defendant does not deny owing the property. He admits owing the property, and he admits his liability for homeowners association assessments to Oakley Township. The defendant's response puts forward several theories, and I classify them as theories or speculation because there is no responsive affidavit in the record. Nothing that the defendant asserts is contained in an affidavit. The assertions that I refer to are these. One, the defendant claims he made a payment for which he has not been given credit. Actually, two payments, but they're really only one payment. That is inaccurate, the assertion that the payment, that he didn't get credit for the payment. The accounting that is attached to the affidavit of Brian Ball gives credit for a payment of $634.10 that the defendant alleges he has not received credit for. It's in there. It might be helpful for the court to perhaps pull up the defendant's response that was filed on February 10.
Got it.
Good. And because I'll be referring to it. It actually proves the plaintiff's case. But again, nothing in the response has been is contained in an affidavit. So as to the payment, the defendant alleges that he made a payment which he claims to have been in the amount of $653.12. When I say he, I mean his counsel claims that, because there is no affidavit here. But if the court looks at Exhibit B to the response, and it might be helpful for me to give some background. The law firm of Winter Capriola formerly represented this community association. In addition, the community association changed management companies from Align Management to Access in November 2020. But at any rate, Exhibit B, defendant's counsel purports to be a receipt from Winter Capriola and Zinner for a credit card payment. And taking that on face value, it appears that it is, and it is accounted for in the plaintiff's accounting. It is in the total amount of $653.12. But if the court looks down on Exhibit B as in boy, under the heading Payment Summary, you will see the amount there, $634.1. plus a surcharge fee of $19.02 to get to the total of $653.12. That surcharge fee is common, on online card payments or payments made by the telephone. I might add my law firm does not do that, but Winter Capriola does. So really the amount of credit from this payment that was made in August 2020 is $634.10. That is included in the plaintiff's accounting. In their response, the defendant goes on to allege or assert, again, there's no proof of this payment. There's no canceled check. There's no proof of a bank statement, saying that he made another payment for $634.10. And what the defendant is claiming as proof of this is apparently a statement which is attached as Exhibit C, showing a payment of $634.10 on September 29, 2020. That is in fact the same payment that was made to Winter Capriola. The defendant's counsel says it's an e-check, but there's a check number on this document that the defendant has put forward. I know as a fact that's Winter Capriola's check that went to the management company as a result of the credit card payment for $634.10. Again, Your Honor, there is no proof, there is no affidavit, there is no documentary proof that there's indeed a separate payment for $634.10. The defendant has not given us a canceled check. The defendant has not given us any authenticated bank records to prove it. And so there is no proof of that. As I mentioned when I started, the principal amount of the complaint was $2,200. We corrected for the $634.19 payment. So the principal amount we're seeking is reduced to $1,040.90. That's what's in the motion for summary judgment, not the amount that the defendant keeps trying to contest. There are other allegations in this response, none of which are proven, none of which has any evidence. One is that they had a payment agreement with the former law firm, but there is no authenticated payment agreement. There is no proof of this payment agreement. There is no proof that the payment agreement was paid in full. There's only the bare assertion of defendant's counsel in the response. Finally, the defendant alleges either that he is paid in full, it appears, or that he was somehow prevented from paying. But the record shows that defendant is not paid in full, and there is no evidence that the defendant made any additional payments that would result in him being paid in full. So just to recap this, the plaintiff's affidavit makes out a prima facie case entitling it to recovery. The defendant must come forward with admissible evidence showing that there is a genuine issue of material fact to get by this motion for summary judgment. We contend the defendant has not done that. Plaintiff is entitled to judgment as sought in the MSJ for $1,040.90 principal, $211.10 prejudgment interest at 10% per year. That is provided by the declaration, $1,590 in attorney's fees, my billing record, and the affidavit is in the record as to the reasonableness and necessity of those fees, $485 in litigation expenses. Again, there's a billing record in my affidavit, and $214 in court costs for a total of $3,541. And that's our case, Your Honor.
All right, thank you very much.
You're
Ms.
welcome.
Claire?
Okay, can I pose a couple of questions to Mr. Joseph just to clarify some things because I'm a bit confused?
Well, the only thing that you can ask counsel, and I suspect these attorney's fees are provided for in the covenants. And I would not suspect, are they reasonable attorney's fees or actual?
Reasonable attorney fees, Your Honor.
All right, then you may cross-examine him on his fees, but why don't you go ahead and tell me what your response is to the motion for summary judgment?
Okay, so our response is that, this is not in a case that is ripe for summary judgment because there are some genuine issues as to material facts, and the plaintiff will not be entitled to summary judgment at this point by law. First, there are some discrepancies in the invoice and the payments. The ledger that we attached to our answer, and if you want, I can share my screen if you want me to pull that up.
Sure.
Okay. Are you guys able to see my screen?
I am.
So I'm going to scroll down to Exhibit C to the defendant's response to the motion for summary judgment. So as you can see, as of, it looks like January 31st, 2020, the annual assessment of $525 was applied. That gave them a balance of $1,127.50. And then the next entry you see is a payment on September 29th, 2020, which was a check for $634.10. But it's missing the August payment that was made by my clients. And this is that payment that went to Winter, Capriola, and Zinner. And it was made on August 17th of 2020 by Ms. Mika Boykin. Now, just a little background, Ms. Boykin is a resident of the property, and she is the girlfriend of Nathaniel Perdue. And so she has participated a lot in the upkeep of the home, as well as corresponding with the association, the property management, and submitting payments on behalf of the property for the assessments. So this payment is missing from this ledger. And this ledger is the same ledger that we got from the plaintiff. So if it's incorrect, it's because it's incorrect on their part. This is not a ledger that my client just made up on their own. So this is the ledger that we got from the plaintiff. And then if you look down, the next document you see is the transaction history for when this was sent to the current law firm, Mr. Joseph's firm, which is, I'm sorry, Ladega and Johansson. So as you can see, it has the prior balance of $493.40, which was the same that was up here, the ending balance in September of 2020. So at this point, they had shut off my client's payment portal. And it had not been restored because there had been several disputes with the HOA regarding payment. So, and I'll let them testify in just a moment. But so this is the previous balance that came from this ledger up above. And then you can see the association fee for 2021 was applied. None of which my clients would have been able to pay at this time because they had already sent this file to the attorney to file suit. And so then you see the attorney's fees added for Mr. Joseph here, which also, at this point it was in, it was being filed suit on, so they couldn't pay with a payment. But they did offer to make payments around this time, but they were not accepted because of the pending lawsuit. And you see that the previous payment was never applied. That's missing. Now this payment did have the incorrect address on it. It has 7382 Mohania Lane instead of 7381. So I'm not sure if there was a mistake on that part. Maybe it was applied to the wrong property. But this was for Nathaniel Perdue's property at 7381 Mohania Lane, and it was made by Ms. Boykin.
Anything else, counsel?
Yes, I'm going to call as a witness Ms. Mika Boykin.
All right.
Your
Well,
Honor,
under what authority are you calling witnesses at a summary judgment hearing?
Just to testify to the fact that, this payment was made on behalf of Nathaniel Perdue and for this account, as well as that she has been trying to make payments since for this account, and the portal was blocked because of the account being sent to collections.
All right, well, the court may have granted you an extension in which to file your response, but I do not believe that there is, but once due, all of your responsive material is due. I mean, if you didn't, I mean, and you tell me what law you're relying on that says you have up until the date of the hearing to produce responsive evidence. And I'm perfectly willing to hear it and could very well be wrong.
Well, I'm sorry, I didn't see it as being responsive evidence. I saw the responsive evidence I filed with these exhibits. But I also, I know counsel is saying that an affidavit is supposed to be filed, but I don't know what law says that the defendant has to file an affidavit with their answer to these types of cases.
Okay, well, I'm specifically looking at Rule 6.5 of the Uniform Superior Court Rules, in which it says the response, it's talking about a motion for summary judgment, that there shall be annexed to the notice of motion a separate, short, and concise statement of each theory of recovery and of each of the material facts as to which the moving party contends there is no genuine issue to be tried. The response shall include a separate, short, and concise statement of each of the material facts as to which it is contended there exists a genuine issue to be tried. So I don't know of any law requiring the court to consider facts after those due dates.
No,
And
I'm
again,
not asking.
if you've got a case or something that says something different, let me know.
No, I'm not asking the court to consider any facts past that due date. The only facts that Ms. Boykin will be testifying to are the same facts.
Yeah, keep talking.
The only facts, will be the same that she's testifying to. It's the same information that we provided in our exhibits. But
Well, go ahead.
But if the court doesn't wish to hear, then we'll just move forward.
Okay, let me just look at this for a minute. Okay. Okay, so I'm reading now from Code Section 9-11-56E. When a motion for summary judgment is made and supported as provided in this code section, an adverse party may not rest upon the mere allegations or denial of his pleading, but his response by affidavits or as otherwise provided in this code section must set forth specific facts showing that there is a genuine issue for trial. If he does not so respond, summary judgment, if appropriate, shall be entered against him. So I'm just, I mean, clearly this is not the first time this issue has come up. Mr. Joseph, do you have anything to add as to whether we take live witness testimony at this stage?
Well, Your Honor, of course, I object to that, and I just simply would have referred the court to Code Section 9-11-56, which requires that evidence be brought before the court in the form of affidavits in order to create a genuine issue of material fact. And that has not been done in this case.
Okay. Ms. Claire, anything further? I mean, I don't,
Of course.
I mean, technicalities can seem very petty, and they can seem to subvert justice at times, but then again, we are entitled to rely on the rules. So tell me what you want me to know.
Okay, so if the court is objecting to hearing the testimony from the defendants, if that's fine, I'll move forward with my argument.
Okay, why don't you do that? Go ahead.
Okay, so the plaintiff's counsel is stating that they only filed a motion for summary judgment for a part of the balance that was in their complaint. So if they're only asking to move forward on summary judgment for a portion of the balance, then that's very confusing, because that would only be a partial summary judgment that could be entered. When someone files a motion for summary judgment, it's usually based off of the entire complaint that they set forth. So we will argue that for that simple fact that counsel is asking for only a part of the balance to be awarded in summary judgment, then there is an issue. There is a genuine issue of fact here as to what was paid and what is owed, as opposed to what counsel has put forth in their complaint as to what is owed. So if there's even a discrepancy about that, then they will not be entitled to summary judgment, because that demonstrates clearly that there is an issue here that needs to be litigated and set forth in trial. The other issue is that summary judgment is not right until after discovery has been done, and that's according to statute. Here, there's been no discovery completed. That discovery may reveal more evidence to show what issues are at hand, and also what payments have been made and how much the defendants may owe or be entitled to. Furthermore, the defendants they can't pay what they're not allowed to pay. So the remaining balance that counsel is saying that they owe, they attempted to pay and it was refused because they had already went to litigation with this. Of course, if they had accepted that payment, they'd have had to dismiss this case. So that amount can't be considered at this time as being owed, as well as the attorney's fees, because they tried to pay and that payment was refused. The opposing counsel said that the ledger that was submitted in their complaint was not missing a payment, but it's the same ledger that we have here. And this ledger is clearly missing a payment. It's missing a payment that was done in August. The plaintiff has also failed to submit any proof otherwise, like they haven't submitted a copy of this check that allegedly was from the other law firm. They haven't shown that this check didn't come from the defendants, like he's claiming. So clearly, this is all something that discovery would help clear up, and even further reason why this case shouldn't be given summary judgment, because they haven't submitted any files or documents to show where these payments came from who they came from, and if a payment is actually missing, which it is. So for all of these reasons, we're arguing that summary judgment not be granted, either partially or fully, which is still confusing to me how they are asking for only part of the amount they demanded in their complaint. Also, I entered into this case a little late, after the defendant had already filed an answer pro se. But if you look at my amended complaint that I filed once I was hired, it further explains everything, and also gives defenses to the complaint that weren't there before. And so the defendants need time to move forward, to request discovery, to make sure that, you know, all the facts are presented correctly, and to litigate this case. And that's why we are asking for the motion for summary judgment to be denied.
Okay, thank you. Mr. Joseph, in your response, would you please let me know whether this is a partial summary judgment or final?
This is final, Your Honor. What we are saying is that we acknowledge that the complaint was for too much, but the motion, because we had not given credit for the one payment of $634.10.
Okay.
That's so having corrected that, what we're seeking in the MSJ is the total owed through the 2020, that is the year 2020 assessment. And if I just might respond to the points made by defendant's counsel, first of all, there is no provision in the rules or the code that says that a motion for summary judgment is untimely prior to the expiration of discovery. However, the defendant filed his answer in September. 6 months has now run, so the time for discovery has passed. Since the counsel has been in the case, no motion for continuance has been filed to conduct discovery. No motion for extension of time has been filed. And until today, the court has not received any mention that the defendant needed discovery. In fact, in a previous filing by the defendant pro se prior to counsel entering the case, he said he had everything he needed in the case. He made that assertion. So I can't understand why now there would have to be discovery. And let me get back to this point that may superficially appear to be a factual discrepancy. The payment for $634.10 that appears on Exhibit C and Exhibit B was obviously made to the prior law firm. It wasn't made directly to Oakley Township. So the prior law firm, just as I would do, had to cut a check, had to mail the check to the association. And then that check had to be deposited and posted. The fact that it wasn't posted until perhaps September doesn't mean that there are two separate payments. It just means that the payment made in August was finally delivered and posted to the association on September 29, 2020, if this ledger is accurate. But there's nothing unusual or unreasonable about that. Finally, it's not the plaintiff's burden to disprove that there are two payments. It's the defendant's burden to prove that he made two payments, or to at least put before the court evidence like a canceled check or a bank record showing two separate payments. The defendant has not done that. The plaintiff has discharged its burden by making a prima facie case showing it is entitled to discovery, as provided by Code Section 91156 and the case law decided under 91156. It is then the defendant's burden to come forward with admissible evidence showing a genuine issue of material fact. I particularly cite the court to the case of Charles S. Martin versus Bernhardt Furniture Company, 213 Georgia Appeals 481, 445 Southeast 2nd, 297. And as the court has observed, the defendant cannot at this stage rest on conclusory allegations, but must come forward with admissible evidence. So for all those reasons, we contend that the motion for summary judgment should be granted and final judgment entered.
Okay, thank you very much. I want to say, first of all, that these homeowner association cases, and specifically fees people owe to stay in their homes, are particularly troubling when we all recognize that sometimes these can accrue to be fairly big debts, and payment by an ordinary individual of a year or 2 years just on the spot is sometimes difficult. That's why we always encourage people to see if they can settle cases, see if they can come up with payment plans. But the fact remains that our rules of procedure are designed so that everybody gets a fair shot, not only to file paperwork, but to respond to paperwork. And at the end of the day, hard decisions have to be made. So I appreciate Ms. Claire's efforts. I appreciate how the defendant feels. I hear how the defendant feels, even though I didn't think it appropriate to hear from him. And I, always hope that people can resolve their differences, but I realize that it's not always possible to just pull out your wallet and come up with thousands of dollars. Nevertheless, the law in this case is clear. The facts in this case are clear. I think Ms. Claire did an incredibly admirable job in trying to come up with a question of fact, but it's not there. Therefore, summary judgment is awarded in the following amount. Mr. Joseph, if you'll prepare an order. The court hereby awards the sum of $1,040.90 as principal, $211.10 as interest, $1,590 in attorney's fees, $485 in expenses, and $214 in court costs, for a total judgment, final judgment, in the amount of $3,541. If you will prepare that, circulate it to Ms. Claire, get it into the court. I appreciate everybody, again, being very patient today, and this matter is concluded. Thank you. Let me get us off YouTube and I will